Okay, we are continuing with Gatley on libel and slander. Judges ruling postponed, where submission of no case is made after the claimant has called his evidence. The judge has a discretion whether to rule on the matter at that stage or whether to defer ruling until the whole of the evidence has been called. Indeed, he can, if he wishes, postpone his ruling until after verdict, and in a proper case, give judgment for the defendant, even if a jury has returned a verdict in the claimant's favor. It has been pointed out that the practice of taking jury before ruling whether there is evidence of malice serious disadvantages where a number of disconnected circumstances by which malice is said to be established come into question. But such a cause can be convenient, for if the Court of Appeal should think that the judge's ruling was erroneous, it will be unnecessary to send the case for retrial to another jury. If the judge, at the end of the claimant's case, does rule that there is some evidence for the jury, he is entitled, at the conclusion of the whole case, to reconsider his ruling and enter judgment for the defendant. If he is then of the opinion that the claimant's evidence fails to disclose any cause of action, or is so weak that a verdict in his favor would be set aside by the Court of Appeal as unreasonable or perverse. Section 2, opening statement on behalf of the defendant. Okay, let's just take some notes on that. So the judge can postpone his ruling on the no case submission. Okay. Very important. Okay, so the next, this is the main thing. 35.2. Section 2. Opening statement. Opening speech. If the defendant intends to call evidence, he may, after the claimant has concluded his evidence, open his case to the jury. In so doing, he has no right to suggest to the jury that they could stop the case and say they had heard enough, or that they could send the claimant away at that stage with a derisory award of damages. Okay. So no calling for of alleged slander. Content of alleged libel or slander for the purpose of showing that the words are not defamatory or will not bear the meaning put upon them by the claimant. The defendant is entitled to have put before the jury the whole article of which the alleged libel forms part, or to give in evidence the whole speech, dialogue, or conversation in the course of which the alleged slander was uttered. If the alleged libel appeared in a newspaper, the defendant may be entitled to put in evidence any other paragraph in the same issue which is referred to in the article containing the alleged libel or is otherwise connected with the article, on the basis that it is part of the context. But if the paragraph is on a different page and there is no reference to it in the article, it may be regarded as too remote in point of situation to have any bearing on the meaning of the alleged article. Whether a paragraph contained in a different edition of the same newspaper but connected with the subject matter of the libel is admissible by the defendant on the issue of meaning is a question that cannot be answered with certainty and probably must turn on whether the paragraph can be regarded as part of the context in which the alleged libel appears. Context may assume special importance to a defendant, relying upon Reynolds privilege. Public interest will be assessed on an evaluation of the interest of the whole article or matter complained of and not wholly by reference to the defamatory statement. Okay, so on the general, the key takeaway is that the defendant may bring in a report of the article to support his plea. From section 3, reference to the claimant. 35.5. When alleged libel is not unambiguously referred to the claimant, and the claimant has called witnesses to prove that the words referred to him, the defendant can call witnesses to state that they read the libel and that they read the libel and did not understand it to refer to the claimant. In such a case, however, if the jury are satisfied that the number of sensible and honest persons reasonably understood the libel to refer to the claimant, it affords nuance to say that other persons did not think the same and understood the words to refer to someone else. Okay. Alright, slander. In cases of slander, the defendant can call any persons who were present to say that he did not hear the words alleged to have been spoken. The defendant can give evidence himself that there was nobody in earshot other than the claimant when he spoke the words. The evidence, however, of one person who swears that he heard the defendant utter the words complained of is, if the jury are satisfied that he is an honest witness of greater weight than that of a number of persons who were present and did not hear the words. All right, so reference to the claimant. Slander. The natural and ordinary meaning of the words, no evidence is admissible by the defendant as to their meaning. If the claimant relies on an innuendo meaning, the defendant may lead evidence contradicting the extrinsic facts on which the claimant relies, or showing that they were not known to those to whom the words were published. In theory, at least, he may also seek natural and ordinary meaning of the words by giving evidence of circumstances known to all who read or heard the words to show but in some other lesser defamatory or innocuous meaning. It will be essential to prove that the circumstances were so known where evidence has been given of facts known to those who read or heard the words, which would lead an ordinary person to infer that they were understood in a secondary and innocent meaning. A foundation will have to be laid for the question, what did you understand by these words? Without such foundation, a witness cannot be asked what he understood to be the meaning of the words complained of. Next is claimant's office, profession, etc. Words are only actionable if they are calculated to disparage the claimant in any office, profession, calling, trade, or business. The defendant may give evidence to show that the claimant did not hold the office or carry on the profession, calling, trade, or business at the time of the publication of the words complained of. So what matters here is at the time of the publication. Okay. So we'll stop there for today. Justification will be next, section 4, proof of justification. for point of 9. Until then,